Well, good morning, everyone. We're resuming the hearing in the case of Stubbs, Davis, and Evans against the Queen. Today, in contradistinction from the 2 days hearings that we've had so far, the appellant is the Queen, and she's represented by Mr. Knox. Mr. Evans is represented by Dan Cooper, QC, and I think we're ready to go. Right, Mr. Knox.
My Lords, if I can just briefly summarise my grounds of appeal. And the first is that the Court of Appeal erred in law and indeed completely misunderstood what happened at trial in saying that the judge should have excluded Higgs's report from the evidence. In particular, it misunderstood that initially the judge required Higgs to attend on the basis that that Thompson could not deal with points that Higgs hadn't covered. That was why the judge initially required Higgs to attend. And then when it turned out that insufficient steps had been taken to get Higgs along, the judge then excluded from the Higgs's report those aspects which Thompson couldn't deal with. That, I submit, was a fundamental error. It simply didn't follow what had happened at the trial. And in particular, it failed to understand the limitations which the judge imposed in allowing the report to go in. And it wrongly held that there was an inconsistency between the judge's 2 respective judgments. There was no inconsistency at all. They were quite consistent with each other. Secondly, the Court of Appeal overlooked that when it turned out that Higgs wasn't going to come along to give evidence, the judge carried out a balancing exercise and held that although there was some disadvantage to Evans, nonetheless the overall interests of justice required the admissibility of Higgs's report through Thompson because of, and I quote, the great probative value of that report, and also because one had to take into account the interests of the community. Court of Appeal just don't take that point on board at all, and they ignore it. And thirdly, in relation to Higgs, the Court of Appeal fundamentally misunderstood the nature of Evans's defence and held that he was in a different position from Stubbs because he didn't dispute having the gun. And it's for that reason, of course, that they turned down Evans's appeal against the conviction for possession of firearms. I submit that was simply perverse. There was no basis for holding that Evans had ever admitted or that he owned the guns, and indeed it's quite apparent from his cross-examination, as pointed out in the dissenting judgment, that his case was that he did not and never had possession of the gun at the relevant time, the gun being the .357. And so we say that was a serious error. And really, that on this point, we say, there's no doubt a point Mr. Fitzgerald would pray an aid. We'd say there's no material difference in the cases relating to Higgs as they affect either A, Evans, or B, Stubbs. They stand in the same position in relation to Higgs' report. There are some minor differences between the two, but we say in substance there was no difference between the two, and the reasons the Court of Appeal gave for dismissing Stubbs' appeal on this point applied equally to Evans. We do also say this, that even if the Court of Appeal's premise was correct, namely that Evans admitted having possession of the gun, then if that was the case, there was simply no sensible defence to the charge. Once you get to the conclusion Evans had the gun, the .357 Magnum, there was only one result. That is, that he was one of the people who had joined in the attack. That is because we know that .357 casings were found just outside the nightclub. And not only found there, but that's where Campbell saw the guns being fired at one point. So we say the Court of Appeal's premise led to the opposite conclusion from the one they came to. My Lords, there are other points which are raised, which the Court of Appeal made, I'll come to those in due course, but we say those secondary points were in each case wrong. There was no basis for overturning conviction on those 3 points. My Lords, what I propose to do is, first of all, deal with the main point, namely, did the Court of Appeal go wrong in relation to Higgs and Higgs's report? I'll then deal briefly with the other 3 grounds. And then, my Lords, I'm in your hands. I propose to deal briefly with the other points made by Mr. Cooper in anticipation, so to speak, of his respondent's notice, and then reply to them briefly. But I'm quite happy to leave them all till the end, but I'm very much in your lordship's hands on that.
Well, it's a matter for you, Mr. Knox. If you're going to deal with him, may I suggest that you deal with him very concisely?
Yes, I'll do that.
If you're going to deal with him, yeah. Right.
My Lords, you'll be familiar with the Court of Appeal's judgment, but it is worth going to again just on the point, did they go wrong in saying that Higgs's report should have been excluded in relation to Evans? And that you pick it up at volume 9, 3397, line 19, paragraph 198.
Yes.
Now, 198, they point out, unlike in the case of the first appellant, the third appellant, Evans, did advance reasons as to why it was necessary in the interest of justice for Mr. Higgs to attend and give evidence. The judge accepted the reasons advanced by the third appellant and ruled in relation to them that it was in the interest of justice that Mr. Higgs give evidence. Moreover, the judge further ruled that the Crown had not taken all reasonable steps to obtain Higgs's oral testimony. My judgment, the third appellant's entitled to rely on that ground. Now, so far as they go at this point, this is correct. They don't actually identify what the grounds were on which Evans had asked for Higgs to attend. And that's important because, of course, those grounds were simply, for the reasons I said yesterday, were simply, well, I want to ask him questions about the clothes and the swaps. She did not say, I want to ask questions about his firearms testing. And then 199, the failure to call Mr. Higgs to enable the third appellant to cross-examine him as to the basis of his analysis that the casings found were fired from the gun recovered by Knowles in the sand was, in my judgment, more prejudicial to him as opposed to the first appellant, who in his statement to the police denied that the gun was his or that he placed it under the car. Unlike in the case of the first appellant, the third appellant in his police interview never said that the gun was not his or that he did not place it in the sand. The issue had not arisen as he hadn't been asked that question before the interview was terminated. Except in his direction to the jury, the judge indicated that the third appellant's case was that the police were lying about him hiding the gun in the sand. The third appellant never, in fact, gave any statement or evidence to that effect. He did challenge the credibility of the evidence of the police witnesses. And then they continue, the ballistics report, or the majority continue, the ballistics report of Mr. Higgs was essential to the Crown's case against the third appellant. It was that the evidence linked the gun found by the police to the shooting, purpose of cross-examination, and so forth. 201, the burden is always on the Crown. Defendant ought not to be deprived of that opportunity to examine the analyst as to the cogency of his evidence, unless there are compelling reasons why this cannot be done. This was not a circumstance of a vulnerable child witness, and so on, nor is this the circumstance where the analyst was dead or couldn't be found. As pointed out earlier, the trial judge held that not all reasonable steps had been taken by the Crown to have him testify, and pointed out in his rulings that there was no explanation as to why Higgs's evidence couldn't be taken by video link, or that any attempt was made to do so. The admission of the report without calling Mr. Higgs was, as the trial judge in fact held, not in the interest of justice. The third appellant asked for him to be called and give evidence. The judge agreed it was in the interest of justice he be called to testify. He gave the Crown an opportunity to do so and found as a fact the Crown hadn't taken all reasonable steps for him to testify. In my judgment, this deprived the third appellant of a fair trial. It's not for this court to now hold that the trial judge was in error when he found that it was in the interest of justice that the analyst be called. The reasons advanced by counsel for the third appellant were credible and accepted by the judge. That's the essential line of reasoning. Now, my lords, What one will notice in my respectful submission is the error in paragraph 199. That is to say, if I may just go back to it, the failure to call Mr. Higgs to enable the third appellant to cross-examine him as to the basis of his analysis that the casings found were fired from the gun, recovered by Knowles in the sand. Now, my lords, that just wasn't the basis on which the judge was asked to get Higgs along by Evans, nor was it the basis on which the judge reversed his initial view that Higgs's report could go in without him attending as a witness. The judge said that we better get Higgs along to deal with the points that Thompson couldn't deal with. That is to say, why hadn't there been any tests, or so it seemed, on the swabs and the clothing. And my lords, I respectfully submit that is fundamental. The Court of Appeals simply haven't understood at all what took place at the various stages of the hearing and why the judge came to his decision. Had they understood it, had they said, well, the reason why Higgs was called to give it, the judge required Higgs to come along to give evidence, was simply to deal with the swabs and the clothing. Had they realized that, they couldn't have come to this conclusion, because they would have then said, well, in his initial ruling, the judge wanted Higgs to come along for one purpose. Later, it turns out that he's not going to be able to come along, so the judge then excludes the relevant bits of the evidence which Evans's counsel wanted him to deal with. And I submit that, therefore, this line of reasoning is completely wrong, because it overlooks why the judge did what he did. And it makes no reference, actually, to the terms of his ruling when he first says we better get Higgs along, nor does it make any reference to the terms of his next ruling when he says, well, now that we haven't got Higgs here, we're going to have to exclude this part of the report, these parts of the report. And in particular, it doesn't make any reference to the judge's finding that it was in the overall interests of justice and the community to allow the report in, notwithstanding there might be some disadvantage to Higgs, to the accused. So I submit the Court of Appeal has fundamentally gone wrong for those reasons. I also submit, for the reasons given by President Longley, that it is completely wrong to say that Evans Evans accepted, or in any way accepted, that the gun, the .357 Magnum, was his, or the one he had possession of. And my lords, if I can ask you to look at the President's judgment, it begins at page 3407, and he turns to this particular topic, and I submit he's plainly right, at 3427, at para 264. And he, unlike, if I may respectfully say the majority, understands here why it was Evans wanted Higgs to come along. Counsel for the appellant, Evans and Stubbs, say they had questions they wanted to put to Higgs regarding his report. Evans's questions concerned swabbing, the nature of the projectiles and continuity. Well, my lords, I'm not sure they did concern the nature of the projectiles, but my lords, one can leave that on one side. Swabbing served no purpose because the case of the third appellant couldn't get better by cross-examination. The only issue was whether he had gunpowder residue on his clothing or body. There was no such evidence, and Thompson was equipped to answer any questions. As for the projectiles, I'm at a loss to see what the issue was. This was a case of who done it. This was not a case of whether the act was done or not. The defence proceeded on the basis that this was a case of mistaken identification. Each appellant said, I had no gun, I didn't shoot anyone. What purpose would be served by calling the witness? Each was denying that he had handled the gun, and there was no evidence that they had any gunshot residue. Neither was saying, I had a gun, and therefore the bullets did not come from my gun, so it's necessary to examine the projectiles to see if any came from the gun I handled. That's not the case. My lords, I adopt all of that. I say that's absolutely right. As such, I can see no case for prejudice by the appellant not being able to cross-examine Higgs, Skiliket, on the ballistics aspect of the report. At no time prior to this, in any of the trials, was any attempt made to cross-examine Higgs, nor did they seek the assistance of their own firearm examiner to test the conclusions reached by Higgs, the firearm examiner Thompson is a local expert who would have addressed their technical questions. In short, nothing was done to call into question the accuracy of Higgs's report. My lords, he then talks about continuity in the chain of custody. My lords, that's not an issue. He carries on, my lords. To my mind, 2.7, to my mind, nothing in the questions took them out of the range of questions that arose because of the perceived difficulty the Crown was having in attempting to secure witnesses' attendance, a witness who hadn't attended any previous hearings. 2.7.1, this was nothing short of an attempt to sabotage the prosecution's case for irrelevancies. The judge was right to refuse the application eventually. In the circumstances, I would rule it wasn't unfair to Evans not to have been able to cross-examine Higgs, and he suffered no prejudice. My lords, he then continues in paragraph 274 to explain why it is the case that obviously Evans did deny having a gun, and that is, he refers to various authorities here, which I submit are plainly correct, to the effect that you can tell what someone's defence is, not only from, let's say, a statement they previously made or evidence, but also from the line of questions they obviously instruct counsel to pursue. And so he refers to some Australian cases. Para 275 is the introduction. As part of his duty to his client, counsel who acts on instructions has an obligation to put his client's case to the witnesses, fairly, fully, and honestly in his defence. Failure to do so may result in an unfair trial. And he then refers to two authorities, which, my lords, I adopt. He then continues, having recited from those authorities, 279, it cannot be gainsaid that one gleans from the case for the defence, from the questions and suggestions put in cross-examination. That is why it is incumbent on counsel to put his client's case to the witnesses' prosecution, to give them an opportunity to respond and to avoid charges of recent invention. In this case, this is what happened. 281. So, for example, at page 382 or page 1519 of the bundle, during cross-examination of Frank Burrows, counsel put the following to the witness. Question, is it not true that you and Officer Robinson made up this story of putting a gun in Clinton Evans' hand, I emphasise, in Clinton Evans' hand, to account for your firing your weapon? Isn't that the truth? No, ma'am. And then earlier, page 1507, the witness answered, while running, Mr. Evans pointed the firearm, indicating, question, I'm going to suggest to you, sir, that never happened, that Mr. Evans at no time had a weapon. I suggest that to you. What do you say to that suggestion? He had a weapon, ma'am. 283, it's clear that what was being asserted by Evans is he at no time had possession of any gun, and that the story was an invention of the prosecution witness. So for the majority to say it was not Evans's case that he did not have a gun is stupefying and out of touch with reality. But the argument that he didn't deny having the gun before the interview concluded is specious at best. It's plain to see why the trial judge concluded in directing the jury that Evans denied having the gun. 286, the majority put a case to the appellant that he himself never put and would have been contrary to his instructions, a recent invention, to support the case now being made that he had questions to put to Higgs. The finding by the majority that Evans never denied having the gun is seriously flawed, not in keeping with the evidence. The case for Evans was conducted on that footing. The reason why he called Officer McClure, and this is important, my lord, was to buttress the defence that he did not have a gun. The majority, my lords, 288 is, I suppose one does find in dissenting judgments a degree of hyperbole sometimes, but the majority of my judgment have engaged in acts of fantasy to reach that conclusion. The case of an acquittal in these circumstances cannot seriously be advanced. Indeed, if the report is admitted, the proviso should be applied and the appeal dismissed. My lords, really, that's my case.
Put a little more trenchantly than would be your style.
Not necessarily correctly. But my lords, I submit it to the heart of the heart of the distinction drawn by the majority between Stubbs and Evans is apparently that Stubbs denies having a gun, whereas Evans accepts it. And that is why, of course, the majority, even the majority, uphold the firearms offence. And I say that is just an impossible distinction. And I submit in anticipation, my learned friend says, well, what's the big point of this case? Well, Why should the Privy Council listen to all of this? It's not your usual practice to intervene, say where there's a serious departure from the rules of justice and so forth. But I submit where you have a completely incomprehensible distinction drawn between two accused, one of whom gets off on the basis of that distinction, the other of whom remains in prison on the basis of that distinction, that is a serious matter, and one that does deserve the intervention of the Privy Council. I do also say that where and this is often happens, where a court of appeal wrongly interferes with the exercise of a judge's discretion, or indeed findings of fact, and misunderstands the basis on which the judge has made his findings, or indeed misunderstands the exercise of discretion, that too, it's proper for a second appellate court to intervene in those circumstances. So I say there is something, this is really the heart. My lords, I don't think really I need to go through, I don't propose in fact to go through at all the same exercise as I went through yesterday, going through the transcript to explain how the case developed. I understand from my learned friend Mr. Cooper that he was listening in yesterday, so he's not going to be taken by surprise by any of what I then said. My lords, can I just mention this in addition to what I said yesterday, briefly? First of all, I was asked yesterday whether there was any learning, asked by Lord Burrows yesterday, whether there was any learning on this point about how should a court approach analysts' evidence as opposed to normal witnesses' evidence. Well, my lords, curiously enough, there are in the bundle two American cases, US Supreme Court cases, one of which is tab 45, which is I think called Melendez-Diaz, which was a case about, I think, possession of cocaine, and an analysis was done on the cocaine, and the analyst wasn't called to actually to give evidence. And the question was that a breach of the Sixth Amendment? Because he didn't come along to give evidence himself. Now, 5 held it was, because under the Sixth Amendment, it's an absolute rule. You are entitled to face your accuser or the witness. The minority, the 4, said, well, it's not a case of, there's never been any question of having the right to confront the analyst. And they said the notion that you should have the right to confront the analyst in the same way as you have the right to confront the witness is completely unhistorical and indeed impractical. But the more important point is they explain in their judgment on a rather higher level why it is that analysts' evidence, it is entirely understandable that one would have a general rule that is admissible without the analyst having to turn up to give evidence. And now that I'm not saying that is they were right or wrong in the particular decision in the case, but their analysis is, in my submission, rather a useful analysis. And I pray it in aid as why it is justifiable for the legislature in section 120 to provide as it has, without the need for the prosecution to call the analyst as a witness. And they expand at considerably greater length than I did yesterday as to the justifications. The case is Melendez-Diaz, and it's at tab 45 of the bundle of authorities. I don't propose to go to it, but I just draw your lordship's attention to it as my Lord Burrows said, objective analysis of what it is, of why it is that analysts' reports should be treated differently. Might be said, if you look at the majority judgment, they say it's not anything but objective. And it's fair to say that there's quite a wide split between the majority and the minority in that case. There is also further discussion on the same point with the same members splitting the same way, 5-4, in the case of Bullcoming, which was a case of analyst's report about driving while intoxicated. I think the issue there was that the person who actually signed the document wasn't the person who did the test. And that gave rise to the problem, well, is he the right person to come along to give evidence? Because if he's not, then the sample shouldn't have gone in. So, and that is Bullcoming, My lords, we only have the majority judgment for that in the bundle, but we did provide yesterday a copy of the entire judgment. So you should, it should be there. It's the minority judgment in Bullcombe, which discusses again the problems of analysts' evidence if you have an absolute rule requiring them to come along to give oral evidence. And there are a lot of what you might call legislative problems to which the Supreme Court drew attention. So I just wanted to add that point. The second point in relation to Evans in particular is that the casings from his gun were KR2 to KR6. My lords, I took you through all this yesterday, but in his case, there are five casings found, and they are .357, all .357 casings, and they also appear to be found around about the entrance of the nightclub. My lords, I gave you the references yesterday.
Yes.
My lords, there's one other point. My learned friend quite rightly points out, but the police too appear to use .357 Magnum guns. So how do we know it wasn't there? How do we know it wasn't their casings, get casings from their guns? My lords, to which my answer is that the place where the casings were found was exactly where the shooting took place, according to Campbell. I gave you the reference yesterday. Conversely, there is no evidence that any shooting took place by the police, that is, at the entrance to the club. The shooting by the police was, if anywhere, as the men were running away from the club, and in particular, as Evans was running away towards the building with a pile of sand. So, my lords, there's no possibility, or no serious possibility, that the .35 casings handed to Higgs were in fact casings from a police gun, nor, I might add, was that ever suggested in cross-examination of the relevant police officers, and that would be Raleigh, because Raleigh was the person who established the chain of command. The chain of continuity. So, my lords, I say that being the case, there was no material distinction between the two cases. And indeed, in one sense, I say Evans's case is more obvious because, for the reasons I gave you yesterday, when you look at the extracts from the transcript, it is quite clear that it was Evans's counsel who was leading the charge about wanting to get Evans along so she could test or ask him why the swabs and the clothing weren't tested. My lord, I can provide references if you like, but I've got certain references to hand. And perhaps I can just mention, I just remind you of the following in relation to Evans, very briefly. First of all, it was she who was the more vocal about removing Higgs from the indictment on the basis that she'd be prejudiced. And I mentioned this yesterday. She specifically objected to Higgs going, and it's at 4:1189, lines 10 to 15 and 25 to 90. So she was the one who was most concerned about Higgs going because she wanted to ask questions about swabbing and so forth. Next, on the 5th of July, when the question of whether or not Thompson should be allowed, the prosecution should be allowed to give notice of additional evidence from Thompson, it was Evans's counsel who said that effectively we're not talking about what we are talking about is testing of projectiles, swabs for gunpowder residue, which is crucial to the case. So she does mention the point there in very broad terms. Then after that, well, that's at 5:1879. But then as you follow the transcript through to 5:1882, what she is actually asking for is Higgs to come along to explain why he hasn't tested the clothing. And then you see the same thing at 5:1893, line 29 to 1894. And then 1906 to 1907. So, my lords, I say, in substance, the two cases stand in the same position, and there's no sensible distinction on the Higgs point between the two. My Lords, likewise, in relation to the summing up, I accept, as I did with Stubbs, that the judge does not specifically draw to the jury's attention that Higgs's was merely a report. But that said, I say, what is the prejudice? And my Lords, I also make all the same points about no prejudice being suffered by Evans by Higgs's report going in, even if it shouldn't have done, for all the reasons I gave yesterday. So I don't need to repeat those. So it's effectively the same points all over again, subject to those minor additions. My Lords, dealing briefly, I hope, with the other grounds upheld by the Court of Appeal. The first is that the judge failed to direct that references in Scott's evidence to the disagreement between, or Scott's deposition, to the disagreement between Evans, his girlfriend, and Davis had no probative value against Evans. And that's at page 3395, para 189. Now, my Lords, I have to admit, I was puzzled by this, and one cannot help but suspect that the Court of Appeal has muddled up Davis's submission with Evans's submission. Because one can see that Davis might say that bit of evidence in the re-examination in the deposition about a fight between him or scuffle between him and Scott, and the reason why Davis was in prison, as mentioned by Mr. Thomas yesterday, one can see that that might be said to be prejudicial to Davis. I submit it's quite impossible to see why it's prejudicial to Evans. My Lords, if I can just take you to the evidence briefly, you saw it yesterday, but if I can just remind you, it's bundle 1, 214, at line 18. This is Scott's deposition. What happened at Grove Station? This is when Evans in person is Davis in person is cross-examining Scott. What happened at Grove Station? Answer: you was acting in a disorderly manner. That's Scott's answer. What happened after that? I put you in your place. So Scott says, I put you in your place. Question: and that's where you know me from. That's the only reason why you come to this court lying, so you can get me back. Me and you had a dispute. You had to touch me up. Didn't you punch me and slap me up? Answer: yes. Question: put me in my place? Yes. And that's the reason why you've come to this court, telling this court this fabricated story. You come seeing me. You getting back at me. You want to be even. Isn't that correct? So that's what Davis is putting to Scott. Now, in my submission, none of that is even faintly prejudicial to Evans. Difficult to see what Evans has got to do with it. Then later, I think this is now a re-examination on 215, you'll see line 8, re-examination by Seymour. Question, line 12. Question: when he described that you touched him up at Grove Station, what happened at Grove Station? Answer: he was arrested, so Davis was arrested, for a complaint made by Evans's girlfriend for threats of death and questioning for firearm. Officer Ambrose arrested him, the deceased, while the Grove Station, he became disorderly. We had a little scuffle in the bathroom. That was the end of it. While being searched, he became disorderly. Now, my Lords, that can't possibly be prejudicial to Evans, however hard you try. So what? Davis has had some sort of altercation, or maybe to do with Evans's girlfriend. So I submit a non-point. And it may be the Court of Appeal was confused with actually Davis's submission. The second point, which the Court of Appeal took, is that there was a failure to warn the jury not to take into account the contents of Stubbs's interview, which made accusations against Evans that Evans, had a gun. And that is at volume 9, 3365, paragraph 189. My Lords, I don't think you need to see the evidence, but if you do, it's at 6, 1945, lines 4 to 10. And the judge reminded the jury of that evidence as part of in summing up Stubbs's interview statement at volume 2, 601, lines 20 to 25. Now, after the summing up, Evans's counsel complained that the judge hadn't given the necessary direction not to take Stubbs's interview into account as against Evans. And then the judge actually gave a direction. And you can see that at volume 2, I'll take you to it, 2, 642, 15 to 23. So this is in what you might call the further summing up. 15 to 23, the court. Madam and members of jury, I just need to give you a few further directions. Firstly, when I gave you a direction in relation to the record of interview of Stephen Stubbs, in the record of interview, quote, me and Darren gone outside and I see Clint Evans beating up one fellow. I see him had one gun. I'm going to tell you that that cannot be evidence against Clinton Evans. Confession is only admissible against the person who makes it. So that cannot be considered to be evidence against Clinton Evans. That's the first thing. My lords, I submit that was a perfectly accurate direction. It should have been given the first time round, but I submit no prejudice has been possibly caused to the jury, sorry, to the Evans, as a result of the giving it later rather than earlier. My lords, paradoxically, the Court of Appeal themselves seem to accept this in a different part of their judgment. 3396, para 194. My lords, no doubt there's obviously an awful lot of quite fiddly material in this case, and it's perhaps understandable, but 3396, para 14, they're talking about Evans's appeal here, all right, 194. As to ground 18, this relates to the confession statement by the first appellant, that's Stubbs, which implicated the third appellant, Evans. In his further directions to the jury, the trial judge made it clear that the statements made by the first appellant in his interview were not evidence against the third appellant. This ground must fail. So, as we're having said at one point it should succeed, they then go on to say later it fails. Well, my lords, I submit that they got it right the second time round, like the judge. And the third point, my lord, is the point that the Court of Appeal finds, and I should take you to this, at 3396, paragraph 197, they say they find the judge's decision not to give a direction on Inspector McClure's evidence was troubling. And you can see it, 3396, paragraph 197, they say, as ground 21, this is a troubling issue. The trial judge categorically refused to put to the jury the evidence of Inspector McClure that no guns were brought to the station when the third appellant was brought in by Officers Robinson and Knowles, notwithstanding that Officer Robinson had said that he and Knowles had personally taken the third appellant to the police station with the gun. The third appellant was inviting the jury to infer that those officers were not credible about the gun, which they said they had recovered from him after he'd hid it in the sand. Whilst that may not be the only inference the jury may have inferred from Inspector McClure's evidence, it appears to us that the third appellant was entitled to have that put to the jury for its consideration. This was not done, and this, in our view, was an error on the part of the trial judge. My lords, it is correct that the judge did not sum up on Inspector McClure's evidence in the initial parts, in the initial summing up. He was asked by Evans's counsel to deal with McClure in the discussion after his summing up, but he refused to do so. And my lords, you can see that at volume 2, 627, line 31. And you can see what the judge's thinking was. Now, I respect this, that the judge is right not to do so. 62731. This is Miss Farquharson here for Mr. Evans at the foot of the page. I would also ask his lordship, there was no mention of Officer McClure. We called her as a defence witness, we didn't mention her at all. Her evidence again, my lord, and his lordship says that suggestions are not evidence. Well, in this case, there wasn't any suggestion put to her to contradict her. You mean in relation to what? The arrest. Who brought Clinton Evans into the station? The court, whether it was Ryan, and then she says Robinson, my lord. Even if we accept Robinson says he arrested him, and he says I took Clinton Evans to the central police station, Officer McClure refers to the detention record, and she says who brought him in. The court, that's her note, Miss Farquharson, my lord, not just her note, that's a police document, his detention record. Yes, it's her note. The court, it's her note. She was the duty officer. There's no contradiction by the Crown that she wasn't, my lord, that's correct. And my lord, if it can be said as well, I know it's been reiterated by you that none of the other witnesses identifies Clinton Evans. You spoke about Ryan, Duncan, and Davis and Stubbs. I thought you'd naturally come to Clinton Evans, but you didn't. And then the court, I'm not understanding that point. Only one person. But you're saying that. You said to them two witnesses did. When you were referring, that's important. So she moves off onto another point. Now, and I think it disappears and the judge doesn't give a direction. Now, in my submission, there was nothing in McClure's evidence that could possibly help the accused, Evans, or at least in any material way. That's my first point. The second point is that if, in fact, the judge did give a direction on McClure's evidence, he would have had to have given a direction also on the effect of what she conceded in cross-examination. And it would have done no good overall to Evans's case if that had happened. Just dealing with the first point, what actually was the state of the evidence? My lords, first of all, what was the evidence of Robinson and Knowles? My lords, I can just summarise very briefly what it was in a few words. Robinson's evidence was that he and Knowles, after they had picked up Evans, drove Evans to the central police station, and then Knowles, who had the gun, went on with the gun on his own to the criminal detective unit. And it was there that Robinson then joined him. So in other words, Knowles just takes the gun all the way to the criminal detective unit. So McClure's evidence added nothing, and it didn't contradict the prosecution evidence, because it was common ground that the gun was not actually taken into the central police station, and therefore nothing turned on, like we say, nothing turned on the fact that Inspector McClure didn't receive it, because the prosecution's case was she didn't receive it. My lords, I can just give you the references to Robinson's evidence. First, Volume 5, 1542, 27 to 32, he and Knowles, at this point, take Evans to the central police station. 5, 1543, 6 to 11, Knowles himself goes on in advance to the central detective unit. And then 5, 1566, 13 to 1567, 1, and 1569, 23 to 1570, line 6, Knowles keeps the gun throughout. So on the prosecution's case, the gun was never taken into the central police station. It was taken on to central detective unit. My lords, I should say Knowles didn't give evidence. He wasn't alive by the time of the third trial. So, my lords, that's what I say. It wouldn't have contradicted the prosecution's case, and it's difficult to see where it would take evidence. But there is another reason, I submit, which is just as good, if not better, and that is if you look at McClure's evidence and the cross-examination, you can see why the judge would, in my submission, have been reluctant to put all this material before the jury as part of the summing up. And it begins at 505, it's a short extract, 505, line 17. If I may ask you to look at that. Now, McClure has by now given her evidence. And this is, I think, it's the prosecution cross-examining. And line 17. Now, I'm going to suggest to you, ma'am, that you were informed that Mr. Evans was alleged to have been in possession of an unlicensed firearm at the time of his arrest. Answer: that I was informed that Mr. Evans was alleged to have been in possession of an unlicensed firearm at the time of his arrest. No, sir. Now, do you agree with me, Inspector McClure, that if that information was in fact given to you, you would have made a record of that in the detention record without looking at it? Ma'am, that he was arrested for being in possession of an unlicensed firearm. The nature of the firearm would have been noted if that information was given to me. Question: Inspector McClure, I'm not asking about the nature of the type of firearm. What I'm asking about, ma'am, is the fact that he was arrested for being in possession of an unlicensed firearm would have been noted by you had that information been given to you. Do you agree with that suggestion? Answer: my lords, this is the important point. It is noted on the front page, possession of unlicensed firearm. So the information was given to you. Answer: the reason they said they brought him in, analogous with the information. Before you continue, where was Mr. Evans at the time this information was given to you? He was still in the charge room. Yes, sir. When the officers brought him in, they brought him in and reported that they were assisting another officer at the time who would have been Ryan, who would have arrested him with reference to possession of an unlicensed firearm. So, my lords, you'll see there, she seems to say it's not Ryan who brought him in, but other officers. Question: is that the only thing he was arrested in connection with? Answer: no. What else was he arrested in connection with? Attempted murder and ammunition, I think. Possession of unlicensed firearm. And then question: Inspector McClure, at the time Mr. Evans was brought into the Central Police Station, you did not personally speak with the arresting officer? Answer: no, sir. No further questions. Now, my lords, if the judge is going to make anything of McClure's evidence, he's got to put all that in. And the last thing, with respect, that's going to help evidence is that there was an immediate and contemporaneous, or to remind the jury, was that there was a contemporaneous and immediate accusation that Evans had been found in possession of a firearm. And that, so to put in half of McClure's evidence wouldn't have helped. You'd have to put all of it in. And if you put all of it in, it doesn't assist at all. My lords, that deals with the Court of Appeal's grounds and on which they upheld the appeal. If I can run through briefly the other grounds relied on. And first of all, if I can turn to what my learned friend calls reason 5, and that is wrongly permitting a doc identification by Campbell and failing to give proper warnings to the jury about doc identifications. My lords, Evans's counsel resisted the admission of the identification parade evidence at volume 2, page 374 to 376. That's where she resisted. My lords, perhaps I should show you this, because there is a slight difference between Evans and Stubbs on this. And it's at line 11 of 374, where one can pick it up from. My lords, this is in, I think, the course of a voir dire, and Evans puts forward her case. The point I want to make here, she puts forward her case, well, look, it's just going to be another doc identification in relation to Clinton Evans. But line 11 and 374, Miss Farquharson, my lord, actually, as I understand the evidence, what I've received is that Mr. Campbell would have attended an identification parade. On that parade, Andrew Davis would have had number 10, Stubbs would have had 5, and my client was number 2. And then this important point, in his first statement, his only statement on the 30th of March, 1999, Mr. Campbell indicates that he picked out number 10 and that he picked out number 2, and he identified number 2 as a man known to him as Di from Richmond Park. My client is Clinton Evans, who had number 2. So in his statement, my lord, he's saying he picked out number 2, but number 2 is Di of Richmond Park, and so forth. And then she goes on to repeat it on page 375, line 14. And her point being, he identified number 2 as Di Stubbs of Richmond Park, to which the court replies, but he picked out the face of your client. He's pointing at Di Stubbs, but saying that's number 2. And then Mr. Ducey. And Miss Farquharson's submission is, my humble submission is this. My learned friends wish to leave what I humbly submit as a doc identification at this stage, and we humbly submit that based on the clear discrepancy, the judge says, I'm trying to understand, doc identification would be where there's been no prior identification at all. And then Ms. Farquharson, this is the other difficulty, because Inspector Mackenzie says he conducted the parade. Evans, he says, was never identified. And so she says, that's why the evidence becomes far more prejudicial than probative. Court, but you cross-examined to that, I can't see the difficulty there. If the person pointed out your client and called him a different name, and describing somebody else, my lord, but I'm humbly submitting to you to permit that evidence to come in before the jury, my lord. Yes, one can cross-examine, but the prejudicial effect would outweigh any probative value. We don't get to the prosecution's case yet, remember that. And then you exercise your discretion, pursue it to 178, and pursue it to prevent this witness from leading or pointing to in the dock to my client. Again, my lord, the prejudicial effect. If I was to probe or cross-examine or suggest to him that you referred to number 2. Court, there has to be sufficient evidence for this case to go to the jury. Remember that, please. And then, yes, I understand, but I'm still saying that doesn't preclude you from giving certain directions to the Crown. And she continues to pursue her point, and the court at the end says, 376, why I'm not understanding you is a case with weak identification without any other support. I don't allow that case to go to the jury. So all the evidence, the admissible evidence in relation to identification, why would I prevent it from going before the end of the prosecution's case? Even if the jury hears that, that's weak identification. On a submission of no case, I will deal with that. And then Ms. Farquharson says, I'm obliged. So essentially, the judge's reason is, well, there is some evidence there. I mean, after all, he picks out number 2, and that is Evans. Okay, you can cross-examine him on the point that he said number 2 is Di. And thirdly, if it turns out at the close of the prosecution case the identification evidence is too weak, I won't let it go to the jury. My lords, I submit that's an entirely rational approach. It is one thing in my submission to say there shouldn't be, the court has to be careful before allowing in what might turn out to be a doc identification. It's quite another thing to say that if there's a risk that there will be a doc identification, the court must exclude it. And that's the fundamental point. And my lords, one must bear in mind that, as my Lord Kerr said in Max Tydo, which I took you through yesterday, doc identifications are not per se inadmissible. If that's the case, the fact that there might be a question mark as to whether an identification is going to be a doc identification or not is one in my submission which is not sufficient automatically to mean that the judge must exclude it. The judge is entitled to do what the judge said here. Well, it may be that there's a risk of this. You can cross-examine on that, and if it turns out the case is too weak at the end, I'll withdraw it from the jury. I say that's a rational approach. And certainly not, in my submission, one vitiated by any error of law. My lords, as to what you might call the other arguments, I simply repeat what I said in answer to Mr. Fitzgerald. Namely, there's no rule that if the identifying officer says one thing and the witness says another, then you must go along with the officer who conducted the parade. And on the facts of this case, there is obviously sufficient reason to suppose that Campbell did pick out Evans at the parade because of the 30th of March statement. There's no doubt he said, I picked out the man at number 2, Evans. And my lords, it's quite a remarkable thing if he did pick out the man at number 2, who's Evans, bearing in mind all the other evidence in the case that suggests that it was Evans, who was one of the shooters. I will also add this. Although in the case of Stubbs, there was, as Mr. Fitzgerald pointed out, there was the point that at the second trial, Mr. Campbell didn't pick out. Well, Campbell did not say he picked out Stubbs at the identification parade. Stubbs, Campbell's evidence in relation to Evans being the man at number 2 and being a man who he picked out was consistent throughout. Preliminary inquiry, first trial, second trial. So again, I submit there was no, even if one approached the matter more broadly, the judge was perfectly entitled to allow the identification to go in, albeit there was a risk it might turn out to be a doc identification if the jury took the view that he hadn't identified Mr. Evans at the parade. My lord, that takes me to the summing up point. And again, my submissions on this are the same as before in relation to Stubbs. The judge pointed out the fundamental inconsistency between Mackenzie and Campbell. I accept the judge did not give a direction to the effect that if you reject Campbell's evidence that he picked out Evans at a parade, then you must treat his pointing him out here in court as a doc identification, and that therefore he did not give any consequential directions. However, I say there's no miscarriage of justice in that, for similar reasons as in relation to Stubbs. It would be obvious to the jury that if Campbell hadn't picked out Evans before, then little weight could be given to the doc identification from the general directions the judge gives on doc identifications, which are 2-573, 17 to 31. Judge gives detailed directions on doc identifications. And I do also say that there's no miscarriage of justice in any event from the failure to give this summing up, given A, the evidence of Robinson and Burrows that they chased after the gun, and they found, and that the gun, the .357 Desert Weapon, was found in a pile of sand. The evidence of Raleigh about where the guns were fired, and the .357, the casing, the .357 casings found, and then Higgs's identification of the casings as such, and what is more, if I need this, Higgs's testing. When you put all that together, there is simply an overwhelming case, I say, against them. My lords, reason 6 given by my learned friend, my learned friend says that there were inadequate directions generally on identification. Court of Appeal dealt with that at volume 9, 3395, paragraph 187. They basically say they could have been more robust, but they're adequate. My lords, I endorse that. The directions in question, I just give you the reference, are at volume 2, 565 to 566, and 568, line 6 to 570, line 29. That's where the general directions are. There is one point that Mr. Cooper takes in addition to the points taken by Mr. Fitzgerald, and that's a clothing point. And that's at page 3914, subpara 3. That's in Mr. Cooper's case. My lords, it is correct that Campbell said in his evidence at the trial, and indeed it seems to match up what he said in his original statement, that Evans had on a red shirt and black jeans. I'll give you the reference. 362, 12 to 16. That's examination in chief. And that it seems to be consistent with what he says in his original 29th of March statement at volume 1, 23 to 26. He is cross-examined fairly extensively by reference to his 29th of March statement by Evans's counsel. In particular, volume 2, 432, 27 onwards, 436, line 13 onwards, 441, line 8 onwards. So there's quite a lot of cross-examination by reference to that original statement. And in particular, Ms. Farquharson puts that there was a motive that Mr. Campbell had a motive for lying. She puts that at 444 to 446. And she also puts that the reason for the differences between his original 29th of March statement and his evidence at trial was that Campbell had been given a nolle prosequi. And also what had happened was that Campbell himself had been arrested, I think, on a charge of attempted rape. And after the events, and he was in prison, I think I'm right in saying, from July 1999 onwards for a period until he was released. And essentially what Ms. Farquharson's line of attack was, come on, you're only saying all this because you've been given a nolle prosequi. That was her line of attack. My lords, the one thing she didn't do was challenge Campbell's evidence about having red and black, that Evans had red top and black jeans on. She didn't challenge that. Now, my lords, what is said is that later it turned out from Ryan and Duncan that, according to them, it was another one of the original suspects called Poitier who had on the red top and the black jeans. You get that evidence at volume 4, 1446, lines 11 to 25. So that's the state of the evidence. No cross-examination on Campbell's evidence, but then police evidence comes out saying the red top and black jeans were worn by someone else. Now, the judge did not give a direction on that point in his initial directions, but it was pointed out to him after his, well, I say initial directions, his summing up. It was pointed out to him afterwards by Evans's counsel that he had failed to direct on this point about the clothing, and so he then did give a direction on the point, which is at volume 2, line 643, page 643, line 29 to 644, line 6. So in my submission, the judge gives the direction, he points out the discrepancy. My learned friend says he didn't go on to say this was specific weakness. Well, my lords, he didn't have to do that. It's obvious that if there's a discrepancy in the clothing between two witnesses, that casts doubt on one or the other witness. So I say nothing really turns on that. And my lords, I do also say there's no substantial prejudice resulting from that alleged failure. My lords, my learned friend deals with certain inaccuracies at page 614, 616 of his case. I don't propose to deal with those at the moment. They are really, in my submission, tiny, and they wouldn't have made any difference. My lords, the next reason given by my learned friend is non-differentiation between Evans and the other witnesses, the other accused. My lords, I dispute that with respect. My lords, if I can just go to the passages which are criticised. First of all, they're fairly short. Volume 2, page 599. Line 31. To page 600, line 6. 59931. Madam Thorne and members of the jury, the record of interview given by the accused men to Detective Inspector Moss contains both incriminating parts and excuses. They all deny that they had a firearm or that they shot and killed Jimmy Ambrose or attempted to kill Marshal Scott. Evans denies he had the Desert Eagle firearm in his possession. My lords, what's said there is that it's not quite right to say, what's said there is they're all lumped together as if they've all got the same defence. When in fact...
Are you on? Forgive me, Mr. Knox, what page are you on?
Forgive me, my lord. 599 page.
Thank you.
To 600.
Thank you very much.
What is said is that there's no differentiation between the three accused, and that Evans was in a slightly different position because he never actually made a specific denial that he had a firearm because his interview was cut short. I think I'm right in saying he never made any specific denial about what his involvement in the incident was. But by the lords, I submit nothing turns on that. And the more important point is that the judge points out Evans denies he had the Desert Eagle firearm in his possession. That was clearly the effect of the cross-examination, even if he didn't say it in his interview statement. The next passage complained of is at page 614, line 15, 614, line 15. Um, 15 to 18. Now, Madam Foreman and members, the three accused men have been identified by two witnesses for the prosecution as being the persons that shot and killed Corporal Jimmy Ambrose. The point taken understandably by Mr. Cooper is, well, that's not quite right in relation to Mr. Evans. He was identified only by Campbell, not by Scott. My lords, I accept that, but it was perfectly clear from the rest of the judges summing up that that was the case, and in my submission, nothing turns on that point. And I might add, I think the passage complained of continues a little bit. Line 19 on 614, they've chosen not to give evidence. The case advanced by each accused through questions put in cross-examination, as the witnesses are lying or mistaken. I've explained the care with which you should approach the evidence of identification. In their interviews with Moss, the accused men all admitted to being present at Club Rock that night and witnessing a fight, but denied they shot and killed Jimmy Ambrose. Well, my lords, I submit that that's maybe lumping them all together, but it is accurate, even if in fact Mr. Evans Evans's interview was cut short. You must remember that the accused men have a perfect right not to give evidence and to require the prosecution to prove its case. They're entitled to sit in the dock and say nothing, therefore require the prosecution to prove its case. You must not assume they're guilty because they haven't given evidence. The fact they've not given evidence proves nothing, one way or the other. It doesn't establish the defendant's guilt. On the other hand, it means there's no evidence from any of the defendants to undermine, contradict, or explain evidence before you by the prosecution. However, you still have to decide whether on the prosecution's evidence you're sure of their guilt. Now, the point taken there is that the judge omits to say, well, actually, in Evans's case, he did actually call a witness. That is Miss Shandiola Colebrook. My lords, that might have been a good point, were it not for the fact that immediately after this, at 615, line 12, the judge goes on to summarise the evidence of Miss Colebrook. And he sets it out at some length and basically says that Evans was not part of the attack. And indeed, he was one of the victims of the attack. So, my lords, I submit there's nothing unfair in the way the judge dealt with it at all. My lords, I think the final point on this is that the judge, it is said, doesn't deal with various points made by Evans's counsel in the cross-examination of Robinson and Burrows. That is, the two police officers who chased after him. My lords, that evidence is it is fair to say the judge summarises Robinson and Burrows' evidence, 589, line 31, to 593, line 28. He does that. It's also right to say that he doesn't deal with the cross-examination and the points put in cross-examination. But, my lords, I respectfully submit there were no substantial points that could properly be put, or which emerged from cross-examination, which were helpful, or which at least wouldn't have been counterbalanced by a direction saying, well, that doesn't matter very much. So I submit nothing turns on the failure to direct specifically on points in the cross-examination of those two officers. My lords, I think that brings me to the final part of my submissions, namely the question of retrial. If I am wrong in my appeal in relation to conviction, then, my lords, we say this would be a case for a retrial, but only on a limited basis, my lords, if I may emphasise. What we say in our case is this: if we accept that, if the Court of Appeal is right on the Higgs point, namely, the judge should have excluded Higgs's evidence, then, my lords, we do not seek a retrial. We accept on the authorities that if the prosecution fails to get its act together in relation to evidence at a trial, it can't come along and say to an appellate court later, well, I tell you what, I know I made a bit of a mistake there. Can we have another trial now, please, so I can put it all right? I accept that, and therefore, if in fact it is right that Higgs's report should have been excluded because the prosecution didn't get him to come along when it could have done, and further, that's a sufficient reason for upholding the appeal, then I don't seek a retrial. We seek a retrial only if your lordships were to uphold the Court of Appeal's decision on all the other grounds which either the Court of Appeal found and any other grounds my learned friend persuades you about. And we say that because this is quite simply an overwhelming case. Once you get to the position that Higgs's report was properly admitted, or at least the evidence, once you get to the position that the .357 casings matched the .357 gun, even if there was no testing, I submit the case is unanswerable for all the reasons I've given before in relation to Stubbs. But my lords, that's very much our secondary position. We say logically, as a matter of the proviso, what if Higgs's report should have been admitted through Thompson, then we say there was only one result in this case, being sensible, because there was no answer to the point that the .357 Desert Magnum, which Evans had, was obviously the gun which fired the .357 casings. There's no other possible explanation. So that's our main point. So the retrial point is really very much secondary. My lords, I think that deals with my submissions.
Right, thank you very much indeed, Mr. Knox. We'll take a break now for 5 minutes and then we'll start with Mr. Cooper. Thank you. Now, I'm sorry for the delay. I'm afraid that was entirely my, well, it was hopefully not my fault, but it was at my end that the delay was occasioned. So, Mr. Cooper.
My lords, thank you very much. Can I just begin by thanking the board for excusing me from day one of the hearing. I have caught up by watching the recording of day one, and I also watched the hearing live yesterday.
Good.
Can I also just very briefly introduce my junior? I appeared with Amanda Clift Matthews, who is with me today in person, and Ramona Farquharson, who is also watching live from the Bahamas. We are together responding to this appeal brought by the Crown against the judgment of the Court of Appeal of the Bahamas, which quashed Mr. Evans' convictions in relation to the murder. Now, my lord, it's important to emphasise at the start that the Court of Appeal granted the Crown leave to appeal automatically, it would appear, without giving any reasons on the merits of the grounds advanced or why leave to appeal was granted. And that is a peculiarity of the statute, which doesn't appear to require any threshold to be met for the purposes of granting leave to appeal. And I do submit that had the board been considering permission to appeal for itself, it would have been a very different matter in terms of the outcome. Thankfully, Mr. Evans was released after the Court of Appeal quashed his convictions. This was not known when the Statement of Facts and Issues was settled, but the Crown have helpfully since confirmed that shortly after the Court of Appeal delivered its verdict, that he was discharged and released from prison, I believe in January 2019, and so he has no restrictions or bail conditions consequential to this appeal. Now, in very brief summary, my lords, I submit that the Court of Appeal was right to say that given the trial judge's findings on the merits of the application of the interests of justice test to the issue of the Higgs report, that he should have been made available for evidence for cross-examination, at the very least by video conference, which wasn't properly explored. It's difficult, my submission, to go behind both the trial judge's fact-specific exercise of his discretion applying that test and the Court of Appeal upholding his initial ruling on that test, that it was in the interests of justice that Higgs be called specifically for Evans, after Evans' counsel gave clear reasons as to why he was required. And that this was a principled decision of the trial judge, that the judge then reversed purely for expediency on, I would submit, a perverse basis, after the Crown recognised it had failed to attempt to secure his attendance, after the judge specifically ruled it should do precisely that. And so I also submit that the Court of Appeal was right to find the trial judge's treatment of the identification evidence in this case was fundamentally flawed, because Inspector Campbell's independent evidence, because Campbell's evidence was contradicted by the Crown's own independent evidence from Inspector Mackenzie. And thirdly, the Court of Appeal was right to find multiple defects in the summing up. That the trial judge's refusal to put to the jury the evidence of Inspector McClure was described by the Court of Appeal as troubling for good reason. The Court of Appeal clearly understood the very fact-specific nature of Mr. Evans' defence, which was that the police officers were not credible in attributing the gun found in the sand by Officer Knowles allegedly to him. And his case was that he was set up by the police, and he made that clear throughout the course of his trials. Fourthly, the Court of Appeal was right to recognise that the judge repeatedly failed to distinguish Evans's case from his co-accused, and failed to set out the factual differences in his defence. And so there were a whole series of factual errors and basic defects, which showed a lack of basic care in the way his case was put to the jury. And it was highly significant in my submission that he was regularly lumped together with the other accused, where there was a much stronger case against them than him, to the extent that basic numerical and factual mistakes were made over the course of fairly limited summings up and directions to the jury. And so I do invite the board to affirm the Court of Appeal decision on these bases. I remind the board that Evans has already been tried for these offences on 3 occasions, in 2002, 2007 and 2013. His convictions reviewed 3 times by the Court of Appeal, twice his convictions quashed, and as well as the unanimous judgment of this most recent Court of Appeal. It's right to recall that the second appeal, Crane Scott JA provided a detailed dissenting judgment setting out why, on a careful analysis, all 4 of Evans's convictions could not stand, after finding a series of errors arising from the judge's directions that rendered the convictions unself. And I further adopt the detailed analysis of Crane Scott in inviting at electronic bundle page 890 from the July 2016 Court of Appeal judgment. And I submit that provides a further useful guide to this board in demonstrating the manifest injustices that led to miscarriage of justice at Mr. Evans's trial. And I would wish to highlight that it was a very fact-specific judgment from the Court of Appeal, which accepted a series of key factual propositions advanced by Mr. Evans as to the clearest of injustice at trial. And so where, for example, Mr. Knox submitted yesterday that but for the admission of the Higgs report, that there was nevertheless, in relation to Stubbs, an overwhelming case against him. It's clear that the basic case against Mr. Evans was tenuous, as it was premised on flawed identification evidence, and so I submit that it's important to recognise that the judge in undertaking the decision on the Higgs report and whether to admit it was exercising a discretion which was only set out on a principle basis in the first ruling. If I can just now turn to the basic reasons that I've advanced in opposition to the appeal. The first point is that there is no important point of law that justifies the board interfering with the Court of Appeal's judgment. And that in itself is a sufficient basis for the board to dismiss the Crown's appeal. And in essence, that's why I highlight the very factual nature of this particular decision, where the summing up and the directions were clearly prejudicial, the central identification evidence, the sole identification evidence was flawed, and the Higgs point turned on an exercise of clear statutory discretion, so I submit that nevertheless that the Court of Appeal reached the correct conclusion in this case. Firstly, because it was clearly in the interests of justice on Evans's case, who was advancing that it wasn't his gun, that he had been it had been planted, he'd been fitted up by the police generally. For Higgs, who was not an independent analyst, who was part of the Bahamas police force, and who hadn't submitted the clothes for testing and conducted his basic job in testing the swabs, that he had clear questions to answer to the jury, which were essential for Evans's particular case to be fairly presented, and so I submit that the Court of Appeal firstly held that the trial judge was right in his first ruling that it was in the interest of justice, and then right to find that the Crown had not taken reasonable steps to secure his attendance, and the subsequent reversal, the volte-face, was irrational and had to be corrected by the Court of Appeal. And so no point of law arose, and nor does the Crown really present this as a point of legal principle. It arose on the specific facts. And so the basic flaw that the Court of Appeal identified was that the report of Inspector Higgs was wrongly admitted into evidence because Section 122 of the Criminal Procedure Code, the test of the interest of justice, was inconsistently applied by the same trial judge who departed from his own ruling merely because the Crown had failed to make attempts to secure Higgs's attendance. And so this further violated Evans' constitutional right to examine witnesses, which was a clear violation on the facts of his case. The next reason is in fact conceded by the Crown, that there were no directions given by the trial judge. Having admitted the report, he failed to properly direct the jury with regards to that untested evidence and the weight that should be attached to the expert report. And you've already been taken to the case of Bain, where the issue of weight is clearly a matter for the trial judge's directions to be concerned with in this situation. And reason 5 is that there should have been no doc ID. My Lord Kerr interjected on day one to ask Mr. Fitzgerald whether, in fact, the point should have gone further than that, and the ID evidence should have been excluded outright. And I submit the answer to that is yes. There should have been. The evidence of Campbell was so fundamentally riddled with inconsistencies and contradicted by the sole independent source set up by the standing force order to verify the correctness of an identification parade witnesses' evidence, that it was so prejudicial that the evidence should not have been adduced at all. But clearly there should have been no doc identification. That was on the shaky foundation that gave rise to it, highly prejudicial, and so the judge wrongly permitted Campbell to make a doc identification in the context of the independent officer making plain that he had not picked out Evans, that he was not identified by Campbell at the parade, and indeed none of the other witnesses picked him out at the parade, and thereafter the prejudice was compounded by the judge's failure to give warnings in relation to the doc identification. And it's significant that the case law is clear that where different directions are required for recognition cases than non-recognition cases. This clearly was not a recognition case. Campbell made plain he didn't know Evans, and that was his evidence, and so the judge failed to recognise that basic distinction in how to address the identification evidence, and indeed whether it justified permitting the doc identification in the first place. And I submit that in itself provides a sufficient basis for dismissing the Crown's appeal. So fundamentally prejudicial was the evidence, but the prejudice continued with the judge's directions on the ID. Generally, reason 6, that the trial judge failed to properly direct the jury on the evidence, the identification evidence as a whole. In particular, failed to direct them of the significance of the independent evidence that Campbell had not identified Evans, which was a glaring omission, and that on previous occasions Campbell had wrongly identified Evans as Stubbs. He failed to direct the jury that the clothing worn by Evans that night was different to the clothing worn by the assailant Campbell in fact described, which was particularly important given another man had been arrested with that clothing, which was not preserved and was given back to him. And then furthermore, the fact that the 3 other eyewitnesses did not pick out Evans was clearly an important point to direct the jury on, which he failed to do. And then reason 7, the judge failed to, he caused substantial prejudice by failing to carefully set out the different case advanced by Evans, the different prosecution evidence against Evans and his defence to it, as compared with the two co-accused. Finally, I submit that in all the circumstances, it would be oppressive and inappropriate to order a retrial in this matter, given that this would be a 4th trial after more than 21 years has passed already. A number of witnesses no longer exist. We heard that Knowles died at a very early stage of the proceedings. He was the officer who allegedly took custody of the gun. There's a lot of evidence that's been lost in the intervening years, and in the context of a failure to undertake the basic forensic testing that would be expected of the police in a case where it is disputed that the gun was ever in the possession of Mr. Evans. And so I invite the board to uphold the decision of the Bahamian Court of Appeal that it would not be in the interest of justice to order a further trial in this case. And it is, I understand, the practice of the board to generally defer to the local Court of Appeal on that issue, that discretion. And yes, my lords, can I take it the court has the basic prosecution case and defence case, which is limited primarily in Evans's case to the identification evidence of Campbell and the ballistic evidence of Higgs, and thereafter a lot of confusion between the other officers as to who was responsible for what, and a lot of contradictions between the officers as to what precisely happened, for example, when the gun was found, and who took custody of the gun thereafter. But the central point is that this is a case of mistaken identification, where the credibility of the officers was directly in issue, which is significant when one considers the justification for cross-examining Higgs in person. And I'll take in due course to the cross-examination of Thompson, that Officer Thompson that followed, which demonstrates just how rigorous and detailed the testing of the report tried to be, and just how inadequate he was in his ability to deal with the points raised. He hadn't even read the notes of Higgs, which his report was based on, and he recognised he wasn't able to deal with the points that Higgs would have been able to deal with. And so it's significant, just that I highlight that, unlike any of the other the two appellants, the respondent's case was that he himself had been attacked outside the club in issue, that he was running away to protect himself when he was first seen, that he was set upon, and that is why he was fleeing the scene. There was at the time of the officers confronting him a separate independent witness who approached the officers to tell them that they had the wrong person, they should let him go. That was a further significant feature of the trial evidence. And so fundamentally, Mr. Evans was clear that the silver Desert Eagle firearm that had the same bullet casings, same bullets and ammunition as that which the police possessed, was never his, and he called positive defence witnesses to establish his case. In Inspector Deborah McClure, who was quite clear as to the fact that she would have recorded the firearm in the custody record had it been brought into the police station, in the context of the officers making plain they did bring it into the police station. I can take you to those references in due course. And so, my lords, if I can just take you now to some of the key passages from the Court of Appeal's judgment. The principal findings of the Court of Appeal was that the report of Higgs should not have been admitted. The identification of evidence of Campbell was inherently weak and unreliable. There were defective some aspects of the summing up. And if I can just take you to paragraph 200 of the Court of Appeal's judgment. One sees here that the Court of Appeal...
Can you give us the electronic page reference, please?
Yes. Sorry, 3397, my lords.
Thank you.
Yes, and so the Court of Appeal recognises the central importance of the Higgs report to the respondent's case because it linked the gun found by the police to the shooting. And I quote that they state the purpose of cross-examination is not simply to advance the case of an accused, it is for the purpose of impeaching the credibility or accuracy of the witness against him and or the case of the prosecution. One of the purposes of cross-examination is to test evidence. The burden is always on the Crown. A defendant ought not to be deprived of that opportunity. This is 201, to examine the analyst as to the cogency of his evidence unless there are compelling reasons why this cannot be done. So that squarely puts the matter in the way that was addressed to you previously in the hearing, that the starting point is the witness, especially a central witness, should be there, and especially after clear reasons have been advanced as to the specific reason and needs on the facts of a particular defence. And then 202, the admission of the report without calling Mr. Higgs was, as the trial judge in fact held, not in the interests of justice. The third appellant asked for him to be called to give evidence. The judge agreed that it was in the interest of justice that he be called to testify. He gave the Crown an opportunity to do so and found as a fact the Crown had not taken all reasonable steps for him to testify. In my judgment, this deprived the third appellant of a fair trial. And then, if I can then just take you to the next point on the unreliable identification evidence, how the Court of Appeal dealt with that. The basic point was that without the report of Higgs, the Court of Appeal was not satisfied that the remaining evidence was of a sufficient quality that a jury properly directed could convict Mr. Evans on these offences based on that evidence. Three reasons were given by the Court of Appeal at paragraph 205, at page 3398 of the bundle. One, the fundamental inconsistencies of Campbell. Two, the officer supervising the parade, Kenzie, made plain, undermined Campbell's evidence. And three, the other eyewitnesses did not pick him out. And then as to the errors in the summing up, the third reason given by the Court of Appeal, which I invite you to uphold, The Court of Appeal essentially recognised there were substantial flaws and unfairness caused by the trial judge's omissions in his summing up in a case that turned on whether the police were credible in attributing this particular gun to Evans. And the court was particularly troubled by the failure to mention at all in the summing up the evidence of Inspector McClure. And I refer you to the dissenting, very detailed judgment of Crane Scott JA, who also deals with this in an authoritative way, if I may say, in recognising that this Inspector McClure was a key witness for Evans in terms of the issue of continuity of the exhibits. In the context of fundamental discrepancies as to what happened between the officers who at the scene who found the gun in the sand. The discrepancies began there and continued all the way through to the police station as to the chain of events. And that made it particularly important in my submission that Higgs was there because he was ultimately responsible for the testing that followed. And so the judge also, the Court of Appeal also recognised that this is 197, that the police were not, there was the trial judge had failed to really address the issue, the defence issue as to the credibility of the officers in relation to the possession of the gun. And yes, and if I can refer to paragraph 197 of the Court of Appeal's judgment. As to the issue of retrial, the Court of Appeal was emphatic in deciding that this was not a... I'm so sorry, my lord. Yes.
Thank you. Just before we leave that area of the Court of Appeal judgment, I wonder if you can help me as to what your position is in relation to what is said at para 199 by the Court of Appeal. The submission of Mr. Knox, I think, was that this showed that the majority of the Court of Appeal had fundamentally misunderstood what the case was. What the Court of Appeal, the majority here, seemed to be saying is that Mr. Evans was not denying that the gun was his, and that was a reason for differentiating his position from Mr. Stubbs. I just wonder what you were saying about what you would say about paragraph 199.
Well, my lord, if one studies paragraph 199 very carefully, in fact, what one sees there is that the Court of Appeal did understand the factual history of the case, and so the Court of Appeal states, unlike, this is five lines down, unlike in the case of the first appellant, the third appellant, in his police interview, never said that the gun was not his, or that he did not place it in the sand. Now, it properly understood that that Evans, so that's a correct factual proposition, that he wasn't asked by the police about that at his interview, because the interview was cut short, and so he was never, that was never a question that was put to him. And then the next point, the issue had not arisen. Yes, and they explained the reason why. I accept that in his direction to the jury, that the judge indicated that the third appellant's case was that the police were lying about him hiding the gun in the sand. Well, that was his case. It was a curious factual feature of this case that his gun was retrieved instantaneously by an officer who came along from a pile of sand when other officers were there, and his case was always that this was a fundamentally tenuous invention to attribute the gun to him and the police casings to him, and then the next.
But the bottom line, if I can just interrupt you for 1 minute, is Evans is denying that the gun was his.
Yes.
Ultimately, Stubbs was denying that the gun was his. The Court of Appeal seemed to think that there's a difference turning on that.
Yes, and I accept that something has gone wrong in this paragraph in drafting, in seeking to distinguish between the two on that basis. But I would highlight that as far as Evans is concerned, the Court of Appeal here clearly understand the factual history in some detail as to the fact that Evans was denying that he had the gun and that it was in the sand, and in fact that and they're correct in saying that he wasn't asked about this in his police interview.
It's really the question whether it was more prejudicial to him than to Stubbs that I'm trying to understand.
Well, my answer to that is that there was greater prejudice to Evans on the failure to permit the Higgs evidence to be tested, because he was challenging the attribution of the firearm to him, and he needed to test the continuity, and he needed, and there was a paucity of evidence against him, and this was a central plank of the prosecution's case. One sees from the cross-examination of Thompson the extent to which the basic methodology of the inspection was put to the test. And so to answer my Lord's question, the answer is yes, there was clearly more significant prejudice to Evans, who set out, because he set out detailed reasons as to how he was prejudiced by not being able to test Higgs in the context of a fact-specific defence of plant, the gun being planted. And my Lord, I'm sorry.
What was the relevance? What was the relevance of the Court of Appeal observing that he hadn't been asked about it in an interview and hadn't denied that he owned the gun? What is the significance of drawing that distinction between him and the two other defendants?
Well, it's fair to say that his case, because of the failure to ask him about this at the correct stage at interview, the failure of the police to resume the interview after it was aborted, meant that he never had the chance to. He was denied the opportunity to advance. This was someone who was not going no comment. He was providing a coherent account of himself to the police at the earliest opportunity, which he was happy to continue to do, but for the police failing to continue the interview at an appropriate juncture. And so the point I'm trying to make, my Lord, is that as a consequence of that police administrative failing, it wasn't until later in the proceedings that his more detailed account emerged as to this particular issue. Sorry.
Yes.
Yes. Yes. Yes. And so I'm just being assisted that, if I can just add that the case we advance is that the Court of Appeal reached the right conclusion on this issue in relation to Evans, albeit that it may have got into a bit of a muddle on Stubbs. I hope that assists. And if I can turn now to the issue of the judgment of the Court of Appeal on the retrial. That the majority found that the retrial would have been caused by the prosecution failing to call Higgs to give live evidence, leaving the admissible evidence at trial insufficient to support a conviction, and wrong to allow the prosecution an opportunity to correct that previous deficiency. And I would just add that if one just stands back for a moment And if we were to imagine how a fourth trial would try to take shape at this juncture 21 or 22 years later, in my submission, it'd be beyond argument that the sole identification evidence of Campbell would be excluded at the start of the trial. It would never go to the jury at all. There'd be not even a doc identification. Higgs would continue to refuse to attend or fail to cooperate with the Crown. And one has to ask oneself, why is it that Higgs had such grave reservations as to making himself available in the context of having failed to conduct his basic duties of testing the clothes, testing the swabs in a defence case that was challenging the entire case on the firearms and maintaining that he hadn't, not only didn't he possess the gun, he didn't fire it at all, so there would be no residue or forensic evidence. And so, yes, and then if I can just make this final point on the judgment, the dissent of the President Longley, it's important to understand exactly how the judgment of the Court of Appeal is constructed, because one of his reasons was that any injustice to Evans caused by the admission of Higgs' report could be cured at a retrial. However, it's important that he was a party to the unanimous decision that upheld Evans's appeal, that the Crown have wrongly asserted in its case on a number of occasions that it was the majority of the Court of Appeal that upheld Evans's the quashing of his conviction, yes, and the Court of Appeal's summary of its judgment confirms it was a unanimous ruling on all three conviction appeals, and that Longley P dissented only in respect to the retrial issue. And Longley P, in fact, confirmed in his opening statement that his disagreement was with the majority is, quotes, in short compass, and that's bundle page 3407, and concerned only the decision to order a retrial. So the Crown's interpretation overlooks the other reasons for allowing the appeal beyond those relating to Higgs' report, where Longley expressed no disagreement, and none of the judges indicated that had only those other grounds of appeal been upheld, they would have applied the proviso and dismissed the appeal. My Lords, if I can just turn now to the detail with respect to the reason one, the issue that there is no important point of law raised by this appeal, and that would justify its continuing. The board has emphasised that it is not to be regarded as a second tier of appeal, that appeals are reserved for substantial miscarriages of justice or where an important point of law has been raised. That is not this case. And these principles obviously apply just as much to appeals brought by the Crown as they do to appeals brought by defendants. And the Crown does not, in fact, claim that there is an important point of law that the board needs to determine in this case, or a substantial miscarriage of justice. And there is therefore no challenge to the Court of Appeal's interpretation of Section 120, which is that the ability to introduce a prejudicial and disputed report into evidence is a discretion that must be carefully exercised. Nor is there any uncertainty in the law with regard to the other matters complained of, as they have all been well traversed by this court already. It's important to note that the Bahamas Court of Appeal Act does not restrict the basis upon which the Court of Appeal may grant leave to appeal. See Section 23 of the Act. Do you need a reference?
We've seen it before, but it'd be helpful if you gave us a reference as you go along.
Yes, I'm so sorry, my lord. It's 3992. That's tab 3 of volume 1 of the authorities. And so yes, and so I rely upon the example of the Mauritian legislation, which allowed appeal to the Privy Council, where the board held that notwithstanding any new legislation, it would continue to be bound by the principles of Ibrahim. And therefore, even where leave to appeal has been granted by the local court of appeal, the board may only consider the grounds put forward where an important point of law, general application, is raised, and it's capable of, if not being reversed, of constituting a precedent not conducive to the public interest in the proper administration of justice. That's Buxer at 824, and the page reference there is 4390, volume 2, tab 23. And I simply submit that that test has not been met by the Crown in this case. Yes, and can I turn now to the identification evidence of which I submit, reason 5, which I submit was fundamental. It was the key evidence advanced by the Crown, and the submission is that firstly that the doc identification was wrongly permitted, and secondly, as conceded, that there was no adequate warning in relation to the doc identification. Yes, the statement of Campbell made on the 29th of March 99 was significant in that it described the person he later attributed to be Evans as wearing a red shirt and black jeans, whereas Evans was in fact arrested wearing a white striped shirt and burgundy trousers. The chronology of the accounts from Campbell demonstrate that he changes at every opportunity he's given to provide his evidence. He essentially shifts his position and changes his account. And so, but the starting point was the parade itself on the 30th of March 1999, where Stubbs was stood at position 5, Davies at 10, and Evans at 2. And what he said was that he recognised, and I emphasise the word recognised, the person standing at position 2 as Di from Ridgeland Park West, i.e. Stubbs. That was his nickname. So in selecting number 2, his comment made clear he purported to identify Stubbs as someone he recognised. And it may well be for that reason that Inspector Mackenzie made clear, and he was charged with the contemporaneous record, the independent supervision of the parade, made clear that he had not, that Evans had not been picked out by Campbell. And if I can just take you to the basic law on the conduct of the parade. The whole purpose of a parade is to independently test the identification evidence, and so fundamental safeguards are built in to the Bahamas Force Standing Order and the rules of practice for the police officers charged with the parade. And pretty much all of the safeguards were breached in this case in the most fundamental way. So paragraph 17 of the order states that one suspect, sorry, this is Authorities Bundle Volume 1, Tab 6 at 4039. Only one suspect only shall be included in a parade unless there are 2 suspects of roughly similar appearance. In no circumstances shall more than 2 suspects be included in one parade, and where there are separate parades, they shall be made up of different persons. And then the parade shall consist of at least 8 persons, in addition to the suspect, where so far as possible, who so far as possible resemble the suspect in age, height, general appearance, and position in life. And then F12.18 of the same standing order requires that where all members of a similar group of possible suspects, separate parades shall be held for each member of the group unless there are 2 suspects of similar appearance, when they may appear on the same parade with at least 12 other members of the group who are not suspect. So these are minimum local standards of safety that must be adhered to. which simply were ignored. And so the basic legal principle is that in relation to a dock identification is that it is not allowed without a satisfactory previous identification. And the authority of that is Goldson at page 4555. And even where dock identification is meant to be a confirmation of an earlier identification, there must be a proper basis for it. And so in the case of Swaby, it was recognised that it is questionable whether the Crown had a proper basis for asking him to make a dock identification, as was done ostensibly merely to confirm an identification already made by the parade, by him at the parade. And so yes, and so the basic point is, from the chronology I've set out in the respondent's case, it can be seen that the pre-trial identifications were at best tenuous. In particular, his alleged identification of Evans at the parade was contradicted by the independent officer, and that meant, quite simply, there was no safe basis upon which a dock identification could properly be permitted. And the factual failures to comply with the local regulations was that all three suspects were wrongly put on the same parade. Suspects were not of roughly similar appearance, and there were only 4 other men of similar size and appearance. But in the end, really, I suppose it's enough simply to rely on the fact that Inspector Mackenzie's evidence was that there was no such positive identification. And I do submit that this was in itself, this evidence in itself was so prejudicial as to render the conviction unsafe in and of its own. And so in terms of the inconsistencies in the identification evidence, it was not simply a matter for the jury. The trial judge considered that Campbell's insistence that he identified Evans at the parade was sufficient to permit the dock identification. But that was to completely undermine the purpose of the standing orders, and the trial judge made no reference to those breaches in his summing up or directions, which he had to do if he was to direct the jury fairly on this issue. And so, as is submitted in the case, these errors amount to an abdication of judicial responsibility to ensure a fair trial, as held in the case of Tito, which is bundle page 5164, volume 4, tab 63. It was for the trial judge to evaluate the quality of the prior identification evidence to determine whether a dock identification by Campbell could be safely permitted. That decision has nothing to do with the jury's assessment of whom they should believe, but the judge's obligation to balance reliability against prejudice. And so, can I turn now to the judge's directions on the dock identification and just explain why they were defective? The basic point is that the judge had a duty to give the most careful of directions to the jury about the risk of mistaken identification associated with dock identification, and to warn them not to put undue weight on Campbell's identification of Evans before them. And so I cite the case of Petersburg, which is electronic bundle 4949, volume 3, tab 50, which underlines how crucial the obligation is for the direction on a dock identification for the fairness of a trial. So a judge does not discharge his duty to give proper directions on the special dangers of dock identification without a prior identification as an identification parade, by giving appropriate directions on the approach to be adopted to eyewitness evidence in general. And in the present case, even assuming the judge given adequate terminal directions on the difficulties inherent in the identification evidence, this does not mean that, taken as a whole, his directions were adequate. So in this case, on these facts, my submission, my lords, is that the trial judge failed to give those directions, and at best they were inadequate. The judge failed to direct the jury that special caution should be applied to Campbell's identification whilst he was sitting in the dock, as he did in relation to Campbell's dock identification of Davis and Scott's dock identification of Stubbs and Davis. So this was an example where actually the prejudice and the unfairness to Evans was greater than it was to Davis and Stubbs, because he gave them that safeguard in his directions, but he simply forgot to do it for Evans on the most critical, central aspect of the prosecution's case. And I rely on the fact that the board has previously ruled that when giving this special warning about identification on Turnbull, the directions must be given individually for each defendant. It's no answer to an omission that a jury would have appreciated that such directions given in respect of one defendant were applicable for identifications generally. And so there is good authority to show the gravity of that omission as it pertains to the safety of the conviction. And secondly, the judge didn't direct the jury that Mackenzie's evidence was independent evidence. Thirdly, the judge failed to direct the jury that if it accepted Mackenzie's evidence that Campbell had not identified Evans at the parade, that then increased the risk that the identification in the dock was false. And fourthly, the failure to direct specifically in relation to the breaches of the safeguards for ID parades contained in the 4 standing orders. Nor did the judge direct the jury on the significance of Campbell confusing evidence with Stubbs in both his witness statements and the preliminary inquiry when addressing the weight to be attached to the dock identification. My Lord, I hope that deals adequately with that particular point. Unless I can assist you further on anything arising from that ground.
Thank you.
My Lord, what follows, reason 6, on the same related issues, is that the judge's inadequate directions on identification evidence generally, and firstly, this really shows that the trial judge failed to distinguish the defendants. And so, aside from directing the jury that Campbell said he had observed the incident for about 5 minutes unobstructed for 15 yards, which was relevant to all the defendants, the judge gave no warning in relation to Campbell's identification of Evans, or analysis relating these warnings to the quality of the evidence in Evans' particular case. And this was contrary to his obligation to do so in relation to each defendant separately. The judge failed to remind the jury of the specific weaknesses critical to Campbell's ID evidence, including the fact that this was not a recognition evidence case. He also failed to deal with the fact that Campbell had wrongly identified Evans as Stubbs in his witness statement at the preliminary inquiry as someone he had supposedly known for 8 years. That was not referred to at all in connection with Evans in the judge's directions. And then, insofar as the clothing is concerned, this was, in my submission, a critical point of significance for the jury to weigh up. The fact that the description of the clothing given by Campbell for the man he identified as Evans that night was different from the clothing that Evans was wearing was important, given that the person with the correct clothing was identified, arrested, and then the clothing was returned to him untested for the gunshot residue. And so the evidence of officers Ryan and Duncan was that the red top and black jeans was being worn by Jerome Poitier, and that precisely matched Campbell's description. The reference there is volume 4, 1446, at lines 11 to 25. And the judge simply didn't remind the jury of this important feature in his summing up. And then finally, the failure to remind the jury that Evans was not picked out by the other 3 eyewitnesses at the parade. It's right to say the judge did attempt to correct some of his errors in his directions after submissions from counsel, but these corrections took place over 2 hours later and were wholly out of context to the judge's earlier directions. So the judge said, in relation to the witness John Campbell, he was asked, "Were you aware that Evans' clothing, his burgundy jeans, pants, and striped shirt was taken from him? This was from Ellsworth Moss." He said, "Yes, ma'am." But the judge didn't go further and explain to the jury that this discrepancy should be taken into account when the jury assessed the reliability of Campbell's identification. So it was too cursory, too out of context, and without sufficient help for the jury to understand the relevance of this evidence when it came out of sequence long after the judge had finished summing up. And so there was no cross-reference to the other weaknesses in the identification evidence. The totality of the strength or weaknesses of the ID evidence could be presented in a coherent manner. And for this reason, I submit that these directions were woefully inadequate to cure the absence of directions on the identification evidence tailored to Evans' specific case as the judge was required to do. Yes, and my lords, if I can move on to reason 7,
Yes.
which is the fact that the judge didn't treat Evans and his defence individually, and the defendants were blurred together on a number of occasions, which was highly prejudicial given the distinct differences in their factual defences. And so there were instead a series of broad generalisations and mischaracterisations where the judge failed to differentiate. And if I can just refer, my lords, we've set out in the case, the respondent's case, the basic law on the purpose behind the summing up. And we rely on the case of Reynolds from 2020 for the proposition that it reminds the jury of the salient facts and the prosecution and defence cases in relation to those facts. Secondly, since a jury's verdict is not reasoned, it provides an assurance that the verdict is founded on the facts described in the summing up, albeit that, as discussed below, it is not necessary for summing up fully to rehearse all the facts and arguments. But it has to deal with the
Yes.
I'm sorry, I temporarily lost everyone, but
Yes,
Please.
we temporarily lost you.
okay.
If you could just recapitulate on what you were saying.
Yes, thank you. And so the submission is that the summing up here fell short of the most basic requirements as set out by the cases such as Reynolds, D, Jones, and Sampson. And so the examples I provide, I submit, are significant, and it's wrong for the Crown to somehow downplay them. And the first is at volume 2, 599, where between 599 line 31 and 606, where the judge, given how short the summing up was, these particular passages carry a special significance in my submission. And so in relation to the defendant's police interviews, the trial judge generalized these interviews rather than distinguishing their differences. And so the judge said they all deny that they had a firearm or that they shot and killed Jimmy Ambrose or attempted to kill Marcion Scott. Clinton Evans denies that he had the Desert Eagle firearm. And then later, the judge stated at bundle page 614, in their interviews, the accused men all admitted to being present at the Club Rock that night and witnessing the fight, but denied they shot and killed Jimmy Ambrose. So really, it's creating an impression in the jury's mind that they can treat these defendants collectively. But the judge didn't address the factual evidence that had gone before them and point out that Evans had never been asked about the shooting or the firearm by the police in interview, or that relevant background to his case, and the account that he provided to the police as to his involvement, which was significant given that it was the first opportunity after his arrest to provide his account to the police. And then insofar as the judge summarised Evans' defence, I submit he wrongly told the jury that it was one of simple denial. All the judge directed the jury about the defendant's respective case was as follows. This is page 614, line 15 to 615, line 11. Now, Madam Foreman, members, the three accused men have been identified by two witnesses for the prosecution as being the persons that shot and killed Jimmy Ambrose. They have chosen not to give evidence. The case advanced by each accused through questions put in cross-examination as the witnesses are either lying or mistaken. In their interviews, Inspector Moss, the accused men all admitted to being present, and so on. And so, the starting point is that well, it's a big factual mistake to make when directing a jury just before it starts deliberating, just to say that Evans has been identified by two witnesses, when in fact the independent evidence has been identified by none. At best, there's one tenuous, but that's not explained, and so the jury is going to be confused into thinking, well, the judge must have got that right. Maybe I misheard the evidence. I'll follow his lead on something as fundamental as that. And so it was incorrect for the judge to well, it demonstrates a laziness of approach to the fundamentals of the evidence on a crucial matter for the jury to determine. And it's significant that the judge, against that background, then refused to summarise Inspector McClure's evidence, even when Evans's counsel highlighted it's important to his defence. And that's Volume 2, 627, line 31, 628, 20, and 645, 30. Now, the cross-examination of Robinson and Burrows was not summarised for the jury either. Evidence elicited that contradicted the suggestion that Evans had a gun or undermined the officer's credibility was thereby omitted from the judge's summation, which only included their evidence in chief. And so, for example, those officers contradicted each other as to whether the gun was shown to Evans when it was retrieved at the scene. Robinson said we showed the gun to Evans. Evans said the opposite. We didn't show the gun to Evans. And then, but if I can refer you to bundle page 1540, line 22, and 1541, line 18, and 1552, line 1. We have there basic differences between Burrows and Robinson as to how the gun was found by Knowles. And that's significant where Knowles could not give evidence because he wasn't alive to do so. And so Burrows said the gun was found in the sand after Knowles juk or pushed his hand into it. And Burrows had made a search of the sand prior to Knowles and came away empty-handed. So there are two differences in how the basic pistol was discovered at the scene. And finally, the judge failed to relate Evans's interview, the cross-examination of Burrows and Robinson, or Colebrook's or McClure's evidence to the issues at stake in order to ensure the jury understood the significance. So, in other words, there's a basic lack of coherence about putting the defence case across fairly. There needed to be some sort of continuous account where these important points were put for Evans alone at the same time, rather than disjointedly, some after the jury had retired and some not at all. But it's really important, in my submission, for the trial judge to give some context and coherence to to his summation of that aspect of the case. And so the consequential submission is that the jury were not equipped for their task of determining Evans's guilt, and on the basis of the judge's summation at trial. Now, the Crown say there was no need for McClure's evidence to be summarised on the basis there was no need for the gun to be noted on the detention record. But that, firstly, there's some factual mistakes based on the Crown's analysis of this issue. But in any event, I submit it is a fundamental aspect of the judge's duty to summarise the defence case on that point, even if the Crown disagrees with it. Yes, so that the Crown assert that the front page of the detention record noted that Evans had been arrested for being in possession of a firearm, and therefore there's no basis for inferring that Robinson's evidence was untrue. But all of the defendants were arrested for possession of the firearm. Naturally, the custody record would state the offence which the offender had been arrested, irrespective as to whether the defendant had a gun on them when arrested or not. The point made by McClure was that if the suspect was brought in with a firearm, an additional note would have been made of that fact on the detention record. And she made clear a note of the type of firearm that was brought in. And so on this point, the evidence of Robinson was clear that he went into the station with Knowles, who had the gun, and so their position was they brought the gun into the station, and therefore the evidence of Inspector McClure was significant in stating that her practice, from her experience, was that it would have been specifically noted in that context.
Yes.
And the reference.
No, it's 1 o'clock, Mr. Cooper, so we'll break off now. We sit again at 2 o'clock.
Thank you very much.